And John Paul, if you can repaste the links. I'm really excited to bring this piece of the training to the forefront. It's on legal information versus legal advice. And anybody who is in the field trying to help underrepresented people is going to have to have a good understanding of what the difference is when you're giving this limited type of consultation. We're really happy to have a presentation by Huda Mitwali, who's also a CUNY Law grad, right?
Yes.
So, and the links, as in prior presentations, are to the training materials and the supporting documentation, to your attendance affirmation, and please fill out the course evaluation at the end. I'm going to hand it over to Hoda, and thank you so much. Please introduce yourself.
Hi, everyone. I'm Hoda. I am a staff attorney for Queens Legal Services, and I full-time staff the Legal Hand Jamaica site. And we are going to begin. So as Lisa said, legal information and legal advice may sound similar, but they actually are two very distinct categories. And in doing any consultation with a prospective client, it is always good to know the differences and the boundaries of what each of these categories are. So I think it's helpful to begin with just reiterating what Legal Hand's mission is. At Legal Hand, we provide free legal information, assistance, and referrals to help visitors resolve issues that affect their lives. These areas can include housing, family law, immigration, divorce, domestic violence, public benefits. There are a few others on here that aren't listed on here, such as employment law. But no matter, whenever possible, we aim to help visitors that are dealing with these various civil legal issues prevent their problems from escalating into legal actions. Inevitably, some of our visitors may be court involved already, and if they are, we aim to guide them towards resources that can best meet their needs. So let's bring it to legal information and legal advice to zoom out. The New York Rules of Professional Conduct specifically have a provision that prevents the unauthorized practice of law. For those of you that are recent law school grads, you probably went over this rule, are familiar with it from taking professional responsibility or the MPRE exam. And the subsection that's most relevant here is subsection B of Rule 5.5, which states, "A lawyer shall not aid a non-lawyer in the unauthorized practice of law." This may seem plain and self-explanatory on its face. The comment goes into further detail about why this rule states what it states and what it means. And in particular, under comment 2, it states that the definition of the practice of law varies based on which jurisdiction you're practicing in. Some states may have a more expansive definition of what the practice of law is. Some may have a more narrow definition. But regardless, limiting the practice of law to members of the bar protects the public against rendition of legal services by unqualified persons. When we say unqualified, I don't mean this pejoratively. I don't mean this to insult anyone or to say anything negative about anyone's abilities, but rather unqualified is meant to be a descriptive term. So for instance, I went to school to learn how to be an attorney. I'm not qualified to be a surgeon. I am not qualified to be a nurse. That is not my training. And simply put, what this comment is establishing is that by limiting who can practice law based on whether one has been admitted to the bar, that works in the interest of the public to ensure that legal services are provided to the public by someone who knows what they're doing and is competent. The comment goes on to say that the rule does not prohibit a lawyer from employing the services of, for instance, paralegals or other support staff and delegating functions to them, as long as the lawyer is supervising those paraprofessionals and ultimately takes responsibility for their work. So for instance, in the course of providing legal services, I could work directly with a paralegal. That paralegal may assist me with different duties such as collecting intake, helping to compile papers that I need to file a motion, etc. But ultimately, it's my job as the lawyer that's supervising them to ensure that the work that that paralegal is doing is sound, that it is up to the basic professional standards. And if that paralegal makes any mistakes, I am the one who's responsible for those mistakes, not the paralegal. In New York, the attorney-client relationship is one that is not delineated by statute, but rather by case law. And the attorney-client relationship is, it's a pretty broad and fact-specific relationship between the attorney and the client that they're serving. There is no bright line rule, but rather there are different tests and different facts that we would look into to determine whether an attorney-client relationship exists. And so this is just a roundup of some of the cases that have dealt with the question of whether an attorney-client relationship exists. These are mostly appellate cases. So some of these principles are, first, what were the parties' words and actions? So what did the attorney and the client say? What did they do? That's always a good starting point to know whether there was an attorney-client relationship between a lawyer and an alleged client. Next, the unilateral belief of a plaintiff alone does not confer upon him or her the status of a client. What that means in plain English is somebody simply thinking that they were the client of an attorney, that alone does not mean that they had an attorney-client relationship. There has to be something more concrete. And as the next case holding states, there must be an explicit undertaking to perform a specific task. So what that could mean, for instance, is the attorney did something actual, something concrete. They performed a task in the service of that particular client. They could have, for instance, put in a notice of appearance, which informs the court that that attorney is the party's representative. They could have filed a motion or filed other paperwork on behalf of that client and signed their name. They could have attended a settlement conference on behalf of that client. There are many possibilities, but the point is that there must have actually been something that the attorney did and not merely a belief on the part of the client. Next, it arises only when one contacts an attorney in his capacity as such for the purpose of obtaining legal advice or services. And finally, it may exist in the absence of a retainer or fee. Okay, so all of the previous slides give you a sense of what an attorney-client relationship could look like, and to an extent, the duty that an attorney may have to their client. When we are talking about those issues, that is more leaning into the universe of legal advice or even legal representation. But what about legal information? Well, legal information is different. Legal information is just a general statement of what the law says. It does not need to be provided by an attorney. It can be provided by a non-attorney who is knowledgeable about the law. Some examples of that are explaining the roles of different agencies that may be able to help, a particular client. Providing plain language definitions of terms. And given that the majority of you are coming out of law school, I think we can all relate to legal terminology being very dense, very heavy, very inaccessible, and just providing the plain English meaning of what a word or a term means is legal information and not necessarily advice. Providing a general outline of what the law says, what different procedures and processes, different court proceedings or administrative proceedings, what they look like. That's general legal information. Providing copies of forms is information. Clarifying available options, for the most part, is legal information, as long as you are not persuading a client to take one particular course of action or providing your own opinion about what is the best option for them. As long as you are just providing the general roadmap of what options are available, that is fine. Offering resources to participants. So that could be providing copies of brochures, know your rights information, generally anything that's available on the newyorkcourts.gov, the Law Help NY, or any free legal service provider's website, as well as the nyc.gov websites, are general informational resources that are not meant to be advice, and those are fine to distribute. And finally, providing information on referrals for different service providers that can actually provide advice or even full representation. What is legal advice? Well, legal advice is much more narrow than legal information. It's the application of the law to a person's specific facts. Legal advice, once someone provides it, can impact a person's legal rights and responsibilities. Unlike legal information, it can only be provided by a licensed attorney. And finally, it creates an attorney-client relationship. So precisely what the previous slides had discussed. Some examples of legal advice are telling someone what they should do, as opposed to telling them generally what options they can consider or can explore further. Another example of legal advice is promising an outcome based on the facts, such as predicting how a judge would rule in a particular case. Another example of legal advice is providing an analysis or interpretation of the laws based on the particularities of the visitor's situation. Everything here on this slide is what we at Legal Hand want to avoid doing. We do not provide legal advice, just legal information. Here are some general tips to keep in mind. As you are working with visitors at Legal Hand, know that your role is to educate, not to counsel. So in practical terms, educating means, what does this person need to know in order to decide what to do? Counseling, however, is asking, what should this person do to further their best interests? Next, know that your goal is to respond to the very general WH questions. So the WH questions are who, what, when used descriptively, when, where, why, and how. I know that how is not a WH, but it's within that general category of questions. However, questions from a visitor along the lines of, should I do this? What should I do? What should I say? What will be the outcome? Those are questions that you want to avoid answering. Some more tips. The word generally is your friend. I use the word generally a lot because in general, no pun intended, there are basic rules and guidelines as to how courts function or how administrative proceedings function. But I always start with the word generally, because inevitably somebody will have a pretty specific question about their own situation. Um, and whenever they do have a very specific hypothetical question, I always inform them, this is the general rule. Um, if you have a question such as this, I think it's a good idea for you to consider consulting with somebody who can provide you with advice on what your next steps are. What I can give you now is just general information. But if you wish to do a more extended consultation, I'm happy to provide you with a referral or give you information on where you could go next. Next, you want to ask open-ended questions. So you may have discussed this a bit in the interview skills training that you all did last week with Omalola, but I think one example of asking open-ended versus leading questions would be, for instance, a visitor comes to you with a set of papers that indicate that they're in housing court. So an example of a leading question that you don't want to ask would be, oh, you didn't pay the rent, right? That's a leading question. That assumes facts that you don't necessarily know, that restructures the intake, that restructures the conversation in a way that it may be presumptuous of the visitor's situation. It may not get you the accurate information about their case that you need to know, and it may cause you to miss some critical questions that you have to ask. It may also, to be frank, it may also send the wrong message to the visitor, that you're making assumptions about them, which we want to avoid. So another way of asking that question in a way that's more open-ended would be, what sort of case are you facing in housing court? Do you have any other information about that case that you could tell me? What happened exactly? Just asking very broad, open-ended questions is always the best way to go, so that you can ensure that you are getting the information that you need from the visitor in a way that does not make assumptions or does not offend them. And also to ensure that you're getting the correct facts about what is happening in their life. Next, you want to be empathetic, but also remain neutral. This can be really hard to do, I admit it. In this particular line of work, especially in the legal services sector, where we serve mostly poor, working class, and low income clients, I think it's very hard not to feel a sense of empathy, or to feel, for instance, if your client is dealing with a major injustice, to not feel angry alongside them or to not feel upset alongside them. We are all humans, and we're all going to feel a certain way, especially when we see our clients coming up against structural injustice, racism, inequality, etc. But at the same time, we have to keep in mind what Legal Hand's mission is, which is to be an informational resource. We are not advocates, and that does limit the extent to which we can work with the people that we serve. We can't represent them in court. We can't do any kind of advocacy on their behalf. And so when you are meeting with a client who is coming to you with a particularly distressing situation, I think it goes a long way to sincerely tell them, no matter who they are, no matter, whether they are a landlord or a tenant, whether it's two roommates that are fighting with each other, whether it's two spouses that are having problems between themselves, no matter what, you can just simply say, I am sorry for what you're going through. I hear you. I hear what you're saying. Let's talk about ways that we can get you to the help that you need. I think it's always best to remain neutral, even beyond Legal Hand's scope of work, just because with the limited interactions that we have with the clients we serve, we also don't know the full story. right? We don't know what's going on in every facet of every visitor's life, and we don't necessarily need to know, but we just need to know enough to make sure that that particular visitor can be directed towards an appropriate resource to help them further. Next, always start with Zendesk, or I guess synonymously, it's referred to as the Legal Hand Helper, as well as newyorkcourts.gov. I would say 4 times out of 5, many of the questions that you may be receiving from visitors may already have the answer already on the Legal Hand Helper or on the New York Courts website. So make sure you start there first, just to ensure that you can efficiently have that conversation with the person that you're serving and get them the information that they need. Some intakes inevitably are going to be much more complex, and that's okay. That happens quite frequently at Legal Hand. That is what myself, Omalola, Jacqueline, I know you're here on the call, James, and the other Legal Hand staff are here to help to assist you all with. But always start with those 2 resources first, because there's a good possibility that your visitor's question, excuse me, may already have an answer up on there. When in doubt, offer to follow up with the participant. And again, that's where the rest of us at Legal Hand step in. It's okay to tell your visitor, you know, I need to check in with my supervisors, or I need to check in with my colleagues. Is it okay that I give you a call back perhaps tomorrow or 2 days from now? When is a good time for you? Try to build in an opportunity to follow up if you're unsure, so that you have a chance to check in with all of us. We are here to help. We don't want any of you to feel lost. We want this to be a fruitful experience for you, and we want our visitors to leave feeling satisfied with the services that they had received. So please don't feel pressured to have an immediate answer right then and there if you're not 100% comfortable. And then check in with us in the meantime, and hopefully we can get that participant and you the information that you both need to efficiently close out that ticket. The next 2 slides are just some side-by-side comparisons of what Legal Hand's informational guidelines are, of what we can and cannot do. And this is just to spell out, using concrete examples, what we can and cannot do. We can explain laws, rules, procedures, and the legal system in general terms. We can explain what the general options available for somebody may be. We can provide referrals to other organizations and local lawyer referral services. We can provide fact sheets and general information resources. We can provide information on how to file a complaint about an attorney or a judge. At least in Jamaica, we get this request pretty frequently. We cannot make recommendations or provide our opinions on what a participant should do. We cannot predict what a court or agency would do. We cannot do our own independent analysis or interpretation of a law or a rule. We cannot communicate with the court, with administrative agencies, with the participant's attorney if they have one already, or the opposing attorney on their behalf. We can provide physical or electronic copies of forms, as well as any instructional cover sheets that come with them. With respect to visitors that need assistance with forms, essentially what we can do is act as scribes. So if a visitor just needs assistance with having a form typed out that they've already handwritten, for instance, or if they can't type and want to dictate what is what they wish to have filled in the form, we can do that. we can enter the information exactly as they provide it to us and then read it back to them. We can double check forms just to make sure that, you know, all the boxes are checked off and that all the signatures are completed. We can provide general glossary definitions of legal and court terms, and we can answer very general questions about court deadlines. However, when it comes to forms, we cannot provide or suggest the words that a participant should write on their court forms. So we cannot check forms for their substance. We can only check them for their completeness, and we can only assist with filling out forms insofar as we're acting like scribes, just writing what the participant wants written out. We cannot answer specific questions about court forms based on the facts of a case. That would be the point at which we would encourage our visitor to speak with an attorney who can advise them, or to make use of other resources that are available that can provide those limited brief services. Unfortunately, we cannot. We also cannot provide or suggest the words that a participant should use at their court hearing. Again, that is something that an attorney who is in a position to provide brief services, advice, or representation can do. We cannot. Finally, we cannot answer questions about statutes of limitations. And just to make sure we're all on the same page, a statute of limitations essentially is the period of time that a person has in order to file a legal claim that they have. Once the statute of limitations has passes, if that person has not filed a lawsuit, they cannot file that particular lawsuit. Occasionally, people will come to us with questions about statutes of limitations and will ask, am I still within the time period in which I can file? We can't answer those questions because that would be advice. Questions about statutes of limitations are essential to whether somebody does or doesn't have a claim. And we would ensure that that person can get a referral to an attorney that can answer that question. Okay, here is a verification code. I will leave this up for about a minute. Make sure to jot this down and to enter the code on your attorney affirmation jot form.
How many credit hours is it?
I believe it's 1. John Paul or Lisa, can you confirm that?
The presentation is an hour, correct?
Yes.
It's 1 credit.
Okay. Let's move on to some practice scenarios. And before we read the question, or rather the prompt and the call, I just want to flag what the main questions that we want to answer for all of these practice scenarios would be. What would be legal information? What would be legal advice? And can you revise or supplement any of these questions? So now that you have that, to help you filter through these questions, let's go to the scenario itself. Yvonne has a dispute with her tenant, Maria, over 6 months of unpaid rent. Yvonne wants to know, 1, should she evict Maria? 2, if she sues, will she get the money she believes she's owed? 3, is it too late for her to sue Maria? 4, how can she get a lawyer? So I'll give everyone a minute just to think about this, maybe jot down some notes.
the third one would be legal advice, right?
Okay, how about we just shout out what we think? And then I'll get to the actual answers. But okay, so you're saying number 3 is legal advice. Okay, any other thoughts?
I think the only one that wouldn't be legal advice is how can she get a lawyer? But I think the other ones could probably be reframed in terms of like telling Maria what her options are.
I agree.
Okay, any other thoughts? All right. You guys are doing great. So you're absolutely right. The first 3 questions, should she evict Maria? If she sues, will she get the money she's owed? Is it too late for her to sue? These are all legal advice questions. Number 1 goes to the question of what she should do, which we want to avoid. Number 2 is Yvonne asking for us to predict what may happen, also legal advice. And number 3 is a statute of limitations question. Number 4, how can she get a lawyer? That's legal information, perfectly fine to provide. And then I just added a 5th as a supplementary question that we can add in, or as one of you suggested, to reframe. We can explain to Maria how the eviction process works. And, you know, in the case of, I'm sorry, we can explain to Yvonne how the eviction process works. And from there, we can answer any generic follow-up questions that she may have. But if she has any specific tailored questions, we would ensure that she gets the referrals that she may need to speak with an attorney to discuss the issue much more in depth. Next scenario. Maria was served with a non-payment petition dated September 15th of this year, 2021. She wants to know, what is an answer? What should she write in it? And what is the exact date by which she must file an answer? So again, let's take a minute and let's determine what of these is legal information, what is legal advice, and can we revise or supplement any of these questions?
I think only the first one is legal information, just what is an answer. The second 2 are kind of legal advice, since you're kind of telling them. Well, the first one you're telling Maria what she should do, and the third one you're telling her kind of the legal deadline for
Okay,
responding.
okay. Any other thoughts?
I think for like I agree with the person before me. For instead of the exact date, we can look up if there is a general time period that an answer should be filed instead of an exact date.
Okay,
The time she has to file an answer isn't the same as the statute of limitations. So is that, so that's, it almost sounds like a little bit of a trick question. So not sure what the answer to number 3 is.
it is a trick question. Sorry, guys. I'll get to the answer slide now. And you all did great. So you're all right. Number 1, what is an answer is perfectly fine. For number 2, what she should write in her answer is, of course, advice that we would want to avoid. With number 3, it's true that an answer is not the same as a statute of limitations. The statute of limitations applies in terms of whether to bring suit for a legal claim, whereas an answer is what a person who's being sued has to file in order to respond to the lawsuit that's filed against them. And we'll talk about this more tomorrow and on Thursday when we go in depth in the housing presentation. So it's true that these are not the same things. But that being said, we want to try and frame questions about deadlines as generally as possible. So rather than providing Maria with the exact date by which she must file an answer, we would want to tell her instead, generally, you have to file an answer within XYZ number of days. And if Maria is beyond that period of time, we would encourage her to speak with an attorney or to contact the courthouse to find more information about what she should do next. But the extent of what we could do is just give her the general period of time rather than going into the specifics or giving her the specific date. And then finally, we can supplement with a question of our own that we'll answer, which is, how can she file an answer? So where does she need to go? What does she need to bring with her? What sort of information should she have ready when she goes to file the answer? Okay, this is our last practice scenario. Maria's in housing court. She's there for a non-payment case. She briefly lost her job for a few months, and she also has had to pay for extra babysitting fees since she's returned to work. She heard that tenants can fill out a document called a hardship declaration, and this declaration can delay their eviction cases. She wants to know, what does she need to know about this hardship declaration? Are her circumstances covered by it? Does she have a good enough case to sign it? And finally, where should she send the signed declaration to?
So I think the first and third questions are kind of both legal information, since you're kind of, well, the first one's definitely legal information because you're kind of just explaining what a hardship declaration is.
Mm-hmm.
The third one maybe needs to be reframed, could maybe be reframed a little bit just to say, as part of like explaining where it can be sent in. I think that's kind of general information, like generally where it's sent.
Okay.
But yeah, the second one's definitely legal advice.
Okay. Any other thoughts? All right. So, yes, you are all correct. Numbers 1 and 3 are general information, questions that we can answer. And yes, using the word generally can go a long way in terms of ensuring that what we are providing is understood as information. Number 2 is definitely a legal advice question because it is asking us to interpret whether the facts of her particular case apply to the law. And at Legal Hand, we're not in a position to do that. And finally, I just added a supplementary question that may come up in the course of the conversation that we could answer. And that is, how can tenants access free legal services? And that is it. So I guess we can move to just open discussion, question and answer, whatever you all would like. We have 15 minutes left, so feel free to make use of this time to discuss anything you'd like or clarify anything that perhaps wasn't clear from the presentation.
I think it's also a really good juncture for sort of raising the issues around the tension between the benefits of being able to provide legal information with the tension of not being able to go further in terms of not as a lawyer wanting to do more, and also just sort of in terms of the overall level of problem solving. And, you know, if folks have any questions or comments about that tension, I think that this is a good place to bring it up. It's Mhm.
No, you go ahead. I can talk when you're done.
No, please go ahead.
Oh, okay. I mean, there is a really big tension, and I think having it laid out so clearly is so helpful. I kind of wish I had it laid out this way like a year ago when I started clinic. Yeah, I guess that's like all I got.
Thank you for that. I wished that I had it laid out like this for me earlier on, you know, when I was a clinical student too, or when I began practicing out of law school. I think that even though the distinction may seem apparent, it's really not. And I think, like to Lisa's point, I think particularly when we are providing direct services to people, and you know, most people on here are CUNY alums, so you know, I think it's fair to say we want to be able to assist people to the best of our ability, but certain professional boundaries dictate that we can't. I think one thing that I wasn't as clear about in the presentation that I do want to flag now is part of why we have to adhere to this distinction is because Legal Hand is open to everybody. So we'll provide information to people regardless of who they are in a particular dispute, regardless of their income. They just have to live within the 5 boroughs. And so what that ends up meaning is, you know, it's entirely conceivable that, for instance, a landlord and a tenant who are both disputing with one another may both independently come into Legal Hand seeking information about their mutual dispute. And for me, like knowing that that is always a potential situation puts, you know, the pressure on me to ensure this is why I have to remain neutral, because I don't know who I may be speaking to. I don't know which side of this dispute this person may be. I'm sorry, could everybody mute? I'm just hearing a lot of feedback in the background.
Thank you. I would just like to comment to the fact that even as almost lawyers, there's a great value in knowing what those boundaries are, both for your own ability at this juncture when you're not a lawyer to be able to do what you can do, but also when you're witnessing other people that are assisting people in need, that you're tuned into what ends up in essence becoming the unauthorized practice of law. And in communities that are starved for actual legal representation, that tends to surface more often than we would hope. And so sort of having that level of nuance when you witness something like that that can be harmful to people in certain circumstances is another aspect of it.
Absolutely, and we see that a lot in the immigration context. We see that a lot with, you know, very exploitative faux practitioners who are not attorneys. They're not even certified by the immigration authorities to provide services, but they will purposefully open up storefront offices in immigrant dense communities and take advantage of people. And then there's notario fraud as well. So part of also communicating this distinction between legal information and legal advice, it's not just about your professional duties and boundaries. That is very important, especially for those of you that are planning to sit for the bar or awaiting admission, but it's also about ensuring that other community members have the basic informational literacy that they need so that they don't get taken advantage of. And it's true, people may get upset and they may say, well, I went to this other office and they told me this, this, and that. And the response to that would be, I understand that you went to that office. I can't comment as to whether what they said was what you should or shouldn't do. I just want you to know what the general resources and information out there says. And if you need to find somebody who is reputable to help you with this issue, this is a resource that you can go to. In the case of immigration, it's Action NYC is where we always send folks, just because there are so many non-reliable and non-trustworthy people in that field. And with something as dire as the possibility of deportation or being separated from your family, we want to ensure that our visitors at least are going to places that are reputable, and not just relying on information that may, or advice that may or may not be accurate and could potentially be harmful to them.
Yeah, I just want to comment that what Hoda said is sort of being able to convey to your client that you want to get them, should they need legal advice, you want to get them there, but that you're not giving it, that you can't give the advice in this setting at the Legal Hand, but that you want them to, if you give them that referral, you want them to want to seek that out, even though it's an effort to make that other call or that appointment, and sort of so they are on the same page that there is something that's a little bit more nuanced and that they need to have that higher level of service. So that's part of what you can do, is sort of get them motivated to take that next step. Were there any other comments or questions?
I'll just say, this may or may not happen to you, but it's worth mentioning. Some clients have come to Legal Hand in the past and have had different experiences working with certain volunteers who were willing to do certain things that are a bit more possibly legal representation more than providing legal information. That does not mean that we're able to provide the same service now as they were able to receive in the past, but they will, most clients will not hesitate to tell you that they feel that that's unfair and that, if we were able to do it before, why aren't we able to do it again? We have to make sure that we're not trying to make exceptions here and there, because it creates inconsistency in the services that we provide. And people are more likely to then go out and tell other people, hey, this is what happened to me. If you want that same service, I recommend you go to this site, or I recommend you talk to this volunteer. That volunteer is long gone now, probably, and no longer knows anything about this or can explain what they did or why they did it. So the best thing for you to do is to just stick with what we're telling you guys right now, because then it's consistent among all of us and we know how to explain why we're taking this stance. If they don't like it, they're entitled to their feelings, but that's something that we can't really budge on, and we don't want to start, making exceptions for people here and there, regardless of the fact that they're probably under a deadline. That makes it even harder for us to be able to help them in those kind of situations. So the best thing we can do is just refer them to organizations that can do more complex work than what we're able to do.
Thank you so much for this presentation. It's still open for another couple minutes for questions. I'm also pointing everybody who needs CLE credit to complete the attendance affirmation and the course evaluation. And Launchpad fellows will see Hoda again tomorrow and Thursday for major housing law CLE trainings. And I'm thinking, and I believe you can complete the recording at this point. And I just ask folks, like I said, to do the affirmation and evaluation. Thank you so much, Hoda.